Our first speaker will be Alexia Tizzano from the European Network on Statelessness. So as ENS's legal officer, Alexia supports law and policy development, strategic litigation activities, and human rights advocacy in the organization. Prior to joining ENS, Alexia worked for EU institutions and also in research. She holds an LLB in law and an LLM in international law. Following that, we'll have a presentation from Marta Jonko, who's the advocacy officer in migration policy at PICUM. Marta joined PICUM in 2019. She previously worked on human rights defenders protection for the World Against Torture, the World Organization Against Torture. She holds a master's in law and an MSc in migration, mobility and development. And Marta, thanks very much for joining us today, and to PICUM for co-hosting this webinar. Without further ado then, I will hand over to the speakers to begin this webinar on detention and returns in the context of protecting the rights of stateless people in Europe. So Alexia, I'll hand over to you for a 15-minute presentation, followed by Marta.
Thank you very much, Francis, and hello everyone, and thank you for joining us today for this important issue. This is the fourth and last webinar in this series, as Francis mentioned. So this series is linked to a series of policy briefings which are on the Stateless Journeys website, and they are available in multiple European languages, and they cover a range of topics, as you can see on the slide. But today we will focus on protecting the rights of stateless people in detention and return. So first, if this is not the first webinar of this series you're attending, you might already know this, but what is statelessness? To be stateless is not to be recognized as a national by any country in the world. It is a legal anomaly that affects over 500,000 people in Europe, both recent migrants and those who have lived in the same place for generations. Statelessness has a devastating impact on access to rights, safety, and belonging. And some stateless people are also refugees. Our Stateless Journeys campaign calls on Europe to fulfill its duties to identify and protect stateless people in the refugee context. And this campaign was developed and continues to involve the people who have a personal experience of statelessness, who call themselves stateless change makers. And some of them are shown on the slides, and there is a lot more information about them on the Stateless Journeys website, and you can hear more from them there. So I encourage you to check this website out. In previous webinars, we saw how statelessness could impact the assessment of asylum claims and children's right to a nationality. And today we'll be looking at another consequence that failing to identify statelessness may lead to, namely arbitrary detention. So what is the issue? The failure to identify statelessness and protect stateless people can lead to unlawful detention and other serious human rights violations. This is linked to the fact that the nature of statelessness means that very often a stateless person has no country to which they can return because no country recognizes them as a national. And so it can be an issue in various contexts. It can be an issue, or there can be detention in a reception context. So stateless refugees are sometimes required to stay in reception centers for prolonged periods due to an uncertainty about their nationality. And in some cases, they are detained or have unlawful restrictions on freedom of movement, which violate the standards of the recast Reception Conditions Directive and other law. Detention can also happen for purposes of removal. So stateless people whose statelessness is not identified or who are not offered routes to regularization, especially in countries which don't have a statelessness determination procedures, are at risk of being arbitrarily detained for long and repeated periods for the purposes of removal, even if they're not able to return to a country of origin or previous residence because they are not nationals. And there can also be a risk of refoulement because stateless refugees from certain countries whose statelessness is not identified in refugee status determination procedures can, at the end of an armed conflict, have their refugee status withdrawn, so seized. And then after, they face a risk of being detained and or forced to return to their country of former residence if they are accepted, to face serious discrimination and or persecution. So here are the words of a person, a stateless man from Pakistan that we interviewed in Poland in 2015, who said, "The waiting is the worst part of detention. It's like you don't have any control anymore. You just sit and wait. You wait for someone else to tell who you are and what is your country." So these words show how challenging immigration detention can be for stateless people whose statelessness has not been identified, and how a lack of awareness from the decision makers about statelessness and nationality can have a serious impact on a person and delay access to protection. So a bit of a state of play on immigration detention in Europe. Detention is quite a problematic issue among countries in Europe. And to learn more about this, you are welcome to check the Statelessness Index, which has more information on that. And despite some harmonization across EU member states bound by the EU Return Directive, law, policy, and practice differ across the region. Even within some countries, the legal framework is complex, sometimes with different types of detention entailing different rights and remedy. Also, data on detention is very limited, with few states that accurately record how many stateless people they detain. As I mentioned, the lack of identification of statelessness also leads to an increased risk of unlawful and arbitrary detention. Statelessness is often not considered a factor increasing vulnerability, and it is rarely considered juridically relevant in decisions to detain. And only a handful of countries in Europe require a country of removal to be identified prior to detaining someone. And legal safeguards to prevent arbitrary detention of stateless people are generally inadequate. Some countries provide procedural safeguards, for example, access to legal aid and regular judicial review, and most countries have set a time limit on immigration detention in law. And finally, although a few countries grant some form of tolerated stay or minimum social assistance to those released from detention, most countries do not provide protection or identity documents on release. And also, it's important to note that tolerated stay is not a form of protection that is fully in line with the 1954 Convention relating to the status of stateless persons. And so it's important to have statelessness determination in place and also adequate referral mechanisms to prevent people from being in a limbo situation, so they can be identified and offered a form of protection or a route to regularization. So what to do as a frontline practitioners? So we came up, as in previous webinar, with 4 R's. So hopefully that's easy to remember. So it's recognize, record, refer, and read up. So first, recognize statelessness. So when considering whether a person's detention is or would be lawful, you could consider whether questions about citizenship and the risk of statelessness have been adequately addressed in screening and or status determination procedures, or if indication of statelessness were recorded, and also explore further if needed. And make sure you're asking the right questions to help identify statelessness or a risk of statelessness. There is a list of questions to help identify statelessness or risk of statelessness, and the list of questions is available on our website, the Stateless Journeys website. So, for example, questions could be, do the authorities of the applicant's home country or any other country consider them to be a citizen? Do they have a right to return with the same range of rights associated with citizenship? Is the applicant part of a group that the government of their country of origin does not recognize as citizens, for example, Kurds from Syria, or Iraq, or Bidoun people from Kuwait? Is the applicant from a territory that is not recognized by all countries as a state, and or where recognition of statehood does not imply full sovereignty or effective nationality of that state, for example, Palestine or Western Sahara? Have previous return attempts failed, and does this indicate that the country of potential return does not consider the applicant to be a national? Have there been delays or difficulties in acquiring travel or identity documents to allow the applicant's return? And does this indicate that the country of potential return does not consider the applicant to be a national? So these are just examples, and many more questions are available on the Stateless Journeys website. And there are also other helpful resources that are listed on the Stateless Journeys website. For example, the EUAA, so the EU Asylum Agency has a practical guide to registration. Our French member Forum Réfugiés also developed a toolkit in France for the identification, support, and referral of people at risk of statelessness. We are also developing a regional toolkit. UNHCR has a toolkit for identification of statelessness in detention. Asylos published a report on stateless Palestinians in Lebanon. We have country position papers on different countries, which provide more information on the main stateless populations from these countries. So there are a lot of resources out there. Then second, record statelessness or a risk of statelessness. It's important to record this early in the asylum registration procedures. So nationality is not assumed to exist where it doesn't. Refer people to get legal assistance as soon as possible and where needed. ENS is always happy to connect you with an appropriate expert if you cannot find one. And finally, read up, because there are lots of resources, as I was mentioning, available on our website. So the ENS main one, the Stateless Journeys website, the Statelessness Index, the Statelessness Case Law Database, and the briefings are a good starting place for those who are new to the topic. So what needs to change at the policy level? First, states must improve procedures for the identification and registration of statelessness. There should be robust statelessness determination procedures, both as standalone procedures and within refugee status determination procedure. Improve laws and guidance to prevent the arbitrary detention of stateless people. There are clear international and European legal standards protecting people from unlawful detention. In many cases, these are reflected nationally in safeguards against discrimination and arbitrariness. However, these safeguards are often not implemented because of the failure to identify statelessness and protect stateless. And improving laws and guidance includes ensuring that statelessness is considered as a relevant fact in detention and return decisions, and that if a person claims to be stateless, they are protected from detention, provided with information and legal assistance, referred to a statelessness determination procedures to establish their nationality or entitlement to protection in the 1954 Convention, and issued identification and basic rights upon release. And also, finally, raise awareness with immigration detention and return actors, including officials, judges, lawyers, NGOs, on people, on the specific situation and protection needs of stateless people, and ensure that they have access to information and resources about statelessness. So we have many further resources available aimed at decision makers as well as frontline refugee support workers and state authorities. And the briefings are really just the first place to look, and they include links to much more information. Ultimately, the protection of stateless refugees is a duty that Europe is too often still failing to provide. However, it is achievable. And the first step is really to understand the issue and to recognize its importance, which is why we are having these webinars, and we really appreciate that you're here and take the time to I'd like to end by quoting one of the stateless change makers, Pavel, who says, "I have nowhere else to go. If I could return somewhere, I would, but I can't, and I have nowhere to go. It could have happened to anyone. It could have happened to you. It is also your problem." Thank you very much, and I'll be pleased to take any questions.
I'm going to present a bit more generally the issue related to migration, detention, and returns in the EU. I put here also my contact information, so feel free to also reach out to me if you have any questions after the webinar today. I'm going to organize my presentation along 4 main different areas. First of all, I'm going to give a bit of a brief overview of what are we talking about when we talk about immigration detention in the EU. Then I would like to speak briefly about some ongoing reforms that are being discussed at EU level and to see how these may affect detention in the EU in the years to come. And then I will move from detention to returns by looking at how the push for an increase in immigration detention is linked also to a push in increasing the number of return rates, and analyzing why this is particularly problematic. And then I will conclude with some recommendations on how we could instead approach these thematics from a different perspective. Immigration detention, to start very briefly from the definition, is the deprivation of liberty for any reasons related to a person's migration status. So we're talking about people who are detained basically for who they are, for the fact of having migrated and having crossed borders, rather than for reasons related to criminal law, which is the case instead of criminal detention. Under the EU law, immigration detention is strictly defined, and the situations in which this is possible are limited. There are 3 main situations for which people may be held in detention for migration reasons. First of all, when they're arriving in the EU to prevent entering the territory and during their identification. Secondly, during the asylum procedure, and this also includes Dublin transfers. And third, when someone receives a return order and when there is a prospect of removal, then they may be detained in specific circumstances to facilitate the return. Usually, when we talk about immigration detention, we talk about administrative detention. So this is regulated under administrative law and not criminal law. It's important to remember that there are very strict rules and safeguards which should apply to immigration detention. Under the international framework, when arbitrary detention is always prohibited, and this is something that should apply to everyone, independent of the circumstances, independent of what they have done. You can't detain someone arbitrarily. And from this principle, which is enshrined in several different international instruments, derives the fact that if you detain someone at borders, on the territory, you do have some legal obligations. You do have to inform them of the reason why they are detained. In fact, any law, there has to be a right to a judicial review. There has to be an individual assessment. There should be a notification of detention. And several other principles that I'm not going to present in depth now, but that are also analyzed in the report that you can see here, which is a recent paper publication on what does the law say on immigration detention. And I'm saying this now because as we might see later, there is a risk that this will change. And we also see that in practice, often member states do not respect these safeguards, which should apply in all circumstances. It's also important to set the scene on immigration detention, to underline, and this was already done previously also by Alexia and some of the statements that she read, but to highlight how detention is always very harmful, is always a disproportionate measure, and it's ineffective. First of all, there are not a lot of available estimates on detention, but based on data from the Global Detention Project, which collects data from each country, more than 100,000 people per year are detained in the EU. So we're talking about very high numbers, and these numbers also include children, families, and in several cases also people who have different types of vulnerabilities. Studies show that even if you're detained for a very short period of time, the impact that this has on your health, on your mental health, and your vulnerability is really high. Different factors contribute to that. For instance, the fact that people are forced to like to step out of their life. They don't know for how long they will be detained. The conditions of detention are often very bad, and generally the lack of safeguards and the fact that they might have lived in a country for years and then they may suddenly be detained and have to leave their jobs, have to lose their houses because of that, leads to very high rates of mental health issues, very high rates of depression, very high risks of suicide for people in detention centers. So it's really important to know that when we're talking about detention and deprivation of liberty, we're talking about what is always a very harmful practice. And for these reasons, there have been a number of reports that have been highlighting this impact and have been calling on states to progressively end detention and apply alternatives instead. And also at the international level and from many NGOs, including PICUM, there is a very strong call to end immigration detention. Despite the very well proven impact of detention on vulnerability and health, we see, unfortunately, a trend at the EU level to increase detention. Many of you might be aware of ongoing discussions on the proposed EU Pact of Migration and Asylum, which was proposed in September 2020, and which is now being discussed by the European Union institutions, with the Parliament having adopted their position in April. Different files and different proposed regulations may increase detention in different circumstances. So the screening regulation may create a situation in which everyone who enters the EU may be detained for 5 days while their identity is screened. This would also apply for children. The asylum procedures regulation would create border procedures in which people would be held at borders in situations which would either amount to detention or what is called de facto detention, which is a situation of deprivation of liberty, but without the safeguards that should come with it, for up to a total of 24 weeks, and also for children. It's still been discussed whether there will be an age limit for children, but generally the inclusion of children and the expansion of detention for children is really problematic. Because there are very clear standards under international law that child detention is always against the best interests of the child, and it's always a child rights violation. Different instruments would also increase risk of detention. The crisis regulation would allow states to have longer deadlines in situations of crisis and extend the time periods for which people could be detained. The return directive, which was mentioned before, is also in the process of being reviewed. And in this review, there would be an extension of the situations in which people might be detained in a sort of automatic way. And lastly, the Schengen Borders Code would also facilitate detention in the context of intra-EU movements and returns within the EU. I'm not going to analyze all of these instruments in detail now. I put here a link to another publication in which we discuss this more in depth, and I'm also happy to share more resources bilaterally by email if of interest. But I think what can be generally drawn as conclusions is that all these instruments would definitely increase the risk of detention and de facto detention, would very much lower the safeguards, leading to risk of arbitrary detention, which, as I mentioned before, is against international law, would increase detention of children, which is, again, a violation of international law. And at the same time, we see concretely that many member states are already implementing plans to expand their detention capacity. They are trying to build new detention facilities, and the European Commission, and a recent recommendation, also encourage states to ensure that they have enough detention capacity for everyone who has received a return order. And this is definitely a violation of the principle according to which detention can only be a measure of last resort and cannot be applied automatically to everyone who is undocumented. There are also studies, in particular a simulation by the NGO Euromed Rights, which shows how, if the pact was adopted, member states would have to increase their detention capacity by 6, 7, or even 35 times. So we are really talking about entire regions basically turning into detention centers. If we look at this very clear push for an increase in detention, the question is, why is there such an interest in building more detention facilities? Why? I mean, we know the detention facilities are costly. Why are states and why is the European Union so interested in building more detention facilities? All of this is based on an assumption which was actually never proven. The assumption is that if you have more detention, you will have more returns. I put here a graph which is based on data from Eurostat, which shows, you can see in blue the maximum detention period in different countries, and in orange the return rates. And you can see that there is actually no correlation between how long people are detained or can be detained and how many people are returned. So I think the first important point is that there is no evidence that detaining people for longer will increase returns. A second important point is to actually question, why do we have this objective of increasing returns at all costs? And this is going to bring me to the second part of the presentation, in which I'm going to look at an increasing push for increasing the number of return rates. You might have heard it in more and more communications by the European Commission already since 2017, more and more policies adopted by member states, which have this objective of increasing the return rates, with the narrative that the problem is that many people receive a return order, but the return order is not implemented. Again, I think this trend is really problematic for two reasons. First of all, what is called return is actually often hiding the terms of deportation. Like, we're talking often about very violent practices. We should not forget that a lot of people have died or have had suffered a lot of harm during the process of deportation. Already in 1998, a 20-year-old woman died during a deportation flight from Belgium to Nigeria. This is still happening. People still suffer different forms of violence during the deportation itself. And after the deportation as well, several people are deported to countries in which they have no ties, in which their rights would be violated. And I put here the link to our publication called Removed, in which we collect a number of testimonies of people who have been deported from the EU to different countries, and that show how deportation itself is really often traumatic. People are uprooted from countries in which they have been living for years and brought to countries in which they have no links, and what happens to them afterwards. From a legal perspective, the idea that everyone who does not receive asylum can be returned, which is an idea that is increasingly being repeated at the European level, is also wrong, because we assume that internationally the only obligations the states have is to respect the right to asylum. In reality, we know that there are several international instruments which set different rights. I mean, we know, for instance, the principle of non-refoulement. There is also an obligation to protect family and private life, to protect the best interests of the child, to protect stateless people, as was also already analyzed before. It's important that all these different human rights obligations are assessed. And for these reasons, we cannot just divide the whole population between people who receive asylum and people who should not be returned. While we see that there is increasing in the narrative a tendency to just oversimplify what is happening and just say everyone who's a rejected asylum seeker should be returned. It is instead important that states take into considerations all these issues, all these fundamental rights aspects before returning someone. We also know that at state level, there are already other permits than asylum, and these permits are in a certain way also a way to ensure respect of international obligations. Studies by European Migration Network show that at least 20 states have different permits than asylum. And often these permits are not analyzed in the context of the asylum procedures. There are also permits, as was mentioned before, for stateless people, for victims of human trafficking, victims of labor exploitation, victims of domestic violence. It is a legal obligation for states to analyze whether people should have the right to apply to these permits. And if people are deported directly after the asylum application has been denied, states would then be violating their obligation to allow access to these permits as well. A couple of years ago, PICUM published a study in which we analyzed these different permits for people who are called like people with barriers to returns, people who cannot be returned for different human rights reasons. And we see that often these permits are insufficient. Many states, I was also mentioned by Alexia, do not have sufficient procedures to facilitate access to these permits. They do not have certain termination procedures. They do not have humanitarian permits, they have medical permits or other permits which are very difficult to access. So it is clear that these national level permits should be improved. But at the same time, it's also important that the existing permits remain accessible and are not further limited. I'm going to move to some recommendations. I think I'm running out of time.
Yeah, if you could wrap up in the next kind of 20 seconds to leave enough time for questions.
Yeah,
thank you.
I'm wrapping up now, so thanks. Just to share some recommendations, as I mentioned before, focusing on the returns is problematic, is harmful, and does not reflect what is actually the reality on the ground. It's important to instead focus on a broader range of permits and to assess different types of permits before someone is issued a return order. And to bring back also to wrap up with connecting with the beginning of my presentation, it's also important that while people go through migration and asylum procedures, that they should have the right to remain in the community, to receive social work support, rather than being detained, because we know that detaining someone does not help them at all to also find the best solution for them. Thank you.
Thanks very much, Marta, for that brilliant presentation. And just to confirm, both presentations will be shared with attendees afterwards. I know there was a lot of really rich information and resources, so you will get copies. I'll go to some questions in the chat now, thanks to those of you who've asked them. To begin with, one from Alex. If one is stateless, where can he or she be deported to? And a second one, that nobody can be, so yeah, unlimited immigration detention, or the unlimited time of immigration detention is one of its key policy challenges, and is particularly difficult for detainees and for those working in detention. Is there a specified time limit for immigration detention, since it can sometimes continue on longer than necessary and be due to unnecessary bureaucracy? The question from Isa too, thank you. Maybe I'll begin by passing to Alexia, and then Marta, feel free to jump in as well. And we've got a few more questions afterwards, so if you could be as brief as possible, that's great.
Thank you, Francis. And yeah, thank you very much to the audience for these questions. For the first question on if one is stateless, where can they be deported? Well, it's a very interesting question, and it's precisely the issue of this webinar. So it might be that they can be returned to a previous country of origin or a previous country of residence. However, if the person is stateless, then this means that no country recognizes them as a national. So it is likely that they will be held in detention waiting for their removal after a return decision. And therefore, they are at risk of being arbitrarily detained if no country accepts them for return, because they are not recognized as national. So it's likely that they are going to be arbitrarily detained for long, prolonged, repeated periods of time for the purposes of. And so, to ensure respect with international law, there is a real need to identify statelessness in return procedures and refer stateless people and people at risk of statelessness to protection routes, in particular statelessness determination procedure and other routes to regularization, as opposed to referring them to return procedures, which will subject them to detention and seeking to execute a removal that will not be practically possible. Should I address the second question? Yeah. So in terms of time limit on immigration detention, so first the EU Returns Directive has some time limit in place. It's in Article 15. So a first consideration is that when there is no reasonable prospect of removal, for legal or other considerations, then detention ceases to be justified and the person concerned shall be released immediately. So that's Article 15, paragraph 4 of the EU Returns Directive. So that's the first time limit, to cease the detention when that aspect does no longer exist. And then for further time limits, then the return directive sets a first limit of 6 months for immigration detention, which can be further prolonged for no longer than 12 months in certain circumstances. And also, I take this opportunity to raise that the European Court of Human Rights has also delivered some judgments on this question and has provided guidance. And there is in particular one case on a stateless person. It's Shoigo versus Ukraine. It's not the only one, but it is one that we have also on the statelessness case law database. And it's about the applicant is a stateless person, and he was detained in Ukraine, and for the purpose of removal and expulsion. And the court found that the authorities did not act diligently when they waited almost 11 months to contact the embassy of the country where the applicant was born. In this case, it was Russia, and obtain documentation to evidence the applicant's Russian nationality. And so, lack of due diligence in trying to assert or to find this information, and they also failed to review the lawfulness of his detention and provide an effective remedy. So, case law is also important, and also is to point also to the CJU, so the Court of Justice of the European Union case law regarding this topic. Also, one case that we can look at is the Katsoev case, which we also have on the statelessness case law database, and which interprets further the reasonable prospect of removal and condition in the EU Returns Directive.
Thanks very much, Alexia. To take a few more questions, another one from Isatu. Can you please comment on the detention of children, since it is particularly controversial? Perhaps Marta, you could take that one. And just to combine it with another 2 questions that were posed, which was another one, what can states do realistically to secure the release of their detained nationals? And how do you ensure that release does not come at too high a cost? Which would like to combine with a question on, are there alternatives to detention? So what does release look like in other contexts? Marta, I don't know if you want to jump in there. We've got 2 minutes left, so not long, I'm afraid.
Yeah, absolutely. I will be very brief. Maybe starting from the last ones, which is, I think, the one which will take a bit longer. There are definitely alternatives. I think there are 2 things which are quite important to mention when we talk about alternatives. First of all, I think we see in particular in the context of the pact, which there is a tendency to consider that other measures which are not detention can be applied in any circumstance. It's important instead to underline that you need to have a ground for detention, you need to have an individual order, and only afterwards states have an obligation to actually consider whether someone could be detained. And if they can be detained, they have also an obligation to consider what alternatives can apply instead. So we see, I think, a trend in applying other forms of restrictions to everyone indiscriminately. When we talk about alternatives are for people who should be in detention. If people should not be in detention, they should be released. And I think this is the first important point. Second important point is that there are many different forms of alternatives. Some are more traditional ones taken from the criminal context, for instance, reporting or bail or surrender of passport. These are important, but they do not really support people through the immigration procedures. It's very interesting to see instead that some NGOs are trialing different forms of alternatives which are based on facilitating the engagement with people with migration procedures, alternatives in which people can stay in the communities and receive support through who is called a case manager, which is someone who really accompanies them step by step through the different procedures. It's called the European ATD network, which is implementing these alternatives in different countries, a level of pilot projects. And these alternatives are proven to work much better because they have much higher also rates in terms of how many people do find a temporary or permanent solution for the migration case. And I think this also replies to the question on what can states do to ensure release from detention. Talking about child detention, this is definitely a really important point because when we talk about children, international standards are very clear. No child should ever be detained for the immigration status or for the immigration status of their parents. For this reason, I think that the standard should be really like different. No children should be detained at all. There have been also several calls, for instance, from the European Parliament, which in the last years adopted 4 different resolutions calling for the end of child detention. But we see that despite that, child detention is actually increasing. I think this is extremely problematic, in particular in the context of the asylum procedures regulation, which would allow, depending on what will be adopted in the end, the detention of all children with their families above 12, or even the detention of children younger than 12. And it's really important to keep in mind that detention, even for very few hours, can have a really traumatic impact on children. The European Court of Human Rights in several cases stated that detaining children, even for short periods, can amount to torture and ill treatment, and this is therefore unacceptable. I think it's interesting to see that some member states are trying to adopt measures in this regard, but I think probably we're short of time, so I'm going to stop here, and I'm happy also to share more information by email if there is interest in that.
Thanks very much, Marta, and sorry to have to cut you off. We have come to the end of time, I'm afraid. But thanks very much to everyone who joined and to those who asked questions. I hope that we've been able to answer at least some of them, although I know there's never enough time.